Hello and welcome once again. We begin tonight with the intervention of the Chief Justice of Nigeria, Justice Tanko Muhammad, on the conflicting orders from courts of coordinate jurisdiction in the country. Now, the Chief Justice, who is also the chairman of the National Judicial Council (NJC), has summoned the Chief Judges of Rivers, Kebbi, Cross River, Anambra, Jigawa, and Imo states to an emergency meeting. This is in a bid to stem the recent wave of conflicting ex parte orders on same issues emanating from judges from different states. The Chief Justice wants the Chief Judges, as heads of the concerned courts, to brief him on the incessant granting of the conflicting orders on suits instituted by different political parties before the various courts.
Well, for more on this, YEMI Candidate-JOHNSON, Senior Advocate of Nigeria, the former President of the Lagos Court of Arbitration, joins us from our Lagos studio. Thank you so much for joining us on Newsnight tonight. First off, let's get your thoughts about this growing trend where courts of coordinate jurisdiction give conflicting judgments. And first of all, tell us what you think about this and what it means for the judiciary.
I think it undermines the reputation and the credibility and the effectiveness of the judiciary. I think that what this spate of decisions shows is a certain recklessness and discipline, and that many of those cases will amount in effect to judicial misconduct. It is highly unlikely that in good faith, 3 judges could give conflicting decisions on one simple issue as to the tenure of office of a political operative. And it seems that the public is right to assume that in some respect the process of law has been subverted.
There are 3 arms of government, as we understand: the executive, the legislature, and the judiciary. How would this turn of events impact on our democracy and polity in general, both in the short run and in the long run?
Well, the federal system of governance that we have mimicked imperfectly is founded on separation of powers, on the rule of law. And the rule of law is the most important aspect of any constitutional legal arrangement. It's the very foundation of not just our government, but the organization of our society. And this, therefore, identifies how important the judiciary is. The judiciary is the guarantor of the rights of individuals, of the rights of governments, of the rights of people between themselves, states, and all the participants in our political union. And that guarantee can only be sustained if the judiciary is competent, if it's independent, and it's impartial. Now, decisions like this, and these are typical of a number of decisions, particularly in the political sphere, which indicates a lack of consistency and very often a recklessness as to the consequences of decisions to be taken. It seems to me that they so severely damage the reputation and credibility of the judiciary that it becomes ineffective for the purpose of which it has been established, which is to maintain the stability of our government, our democracy, and the safety and confidence of our people. If people can't have confidence in the independence and impartiality, the competence being assumed of judges, then the entire system will come to a grinding halt and there will be disorder.
The Chief Justice of Nigeria, Mohammed Tanko, has summoned the affected states here, Rivers, Kebbi, Cross River, Anambra, Jigawa, and Imo State. What are the options in terms of internal mechanisms to actually, if indeed these Chief Justices are found to have, compromised the system in any way or form, what are the likely punitive measures in place that the CJN and, of course, the Judicial Council, the NJC, can actually apply?
Well, let me start off by correctly characterizing what appears to have gone on with these decisions. Now, there's no doubt in my mind that one or more of those judges is guilty of judicial misconduct. And if a series of high-profile, inconsistent decisions were given by judges across states and judges of coordinate jurisdiction, I myself would consider that there was warrant for a corruption inquiry. That being said, the Chief Justice of Nigeria, although he has no direct supervisory authority over individual judges in the exercise of their constitutional power, has a responsibility as the leader of the Nigerian judiciary, the most prominent judge, and the chairman of the National Judicial Council, which has responsibility for discipline and regulation of the conduct and providing for standards for judges to apply. In that regard, I would expect that when he calls the chief judges, he has at the very least moral suasion. He has before him and the power to, not a coercive power, but the fact is they must recognize that judicial discipline is going to come before a committee that he chairs. Now, for a judge in a state to give a decision which may well prove to be unfounded and potentially corrupt, the chief judge of the state is the person to be held directly responsible, because the assignment of cases in states is a power that belongs to the chief judge. And if the chief judge cannot guarantee that the judges he assigns cases to or he allows to have cases assigned to them can conduct themselves in a way that is responsible, that is lawful, and that is credible, then one needs to wonder about the competence and capacity of such a chief judge.
You're a senior advocate of Nigeria, YEMI. Do you think that there is not enough checks to discipline erring judges, reason why this embarrassment, as the CJN describes it? I want to find out.
Yes. Yeah, you know, there is a mechanism for disciplining judges, and this is the National Judicial Council, which has a cumbersome procedure for approaching, and there are impediments and some bottlenecks with approaching the Judicial Council, because the Judicial Council, I think, is primarily concerned with the integrity and the dignity of judges rather than in the effectiveness of their function for the people and their accountability to the people who they serve. Now, this is the upturning of the concept of judges and judiciary and judges. Judges, I think, tend to think that they're a mysterious cult which deserves some special reverence, and to an extent they do, because they administer justice, which is the fundamental of our organized society. But above all, they are public servants delivering a service at the public expense for the use and consumption of the public. And in that regard, the people to whom they must be accountable most directly is the public. If the public has no confidence in judges, then they have already failed in their function. And so the organization of the system of accountability, I think, needs to be improved to a great degree. In many other countries, judges are directly responsible to non-judicial bodies. In the UK, for example, the Judicial Appointments Commission and the Judicial Discipline are majority laymen. What we have in Nigeria is a closeted and cloistered system where judges supervise judges, and therefore they apply only principles. Whatever mechanism you have is only as functional as the intention behind which, by which is operated, and the intention of those who operate it. And I think that what you find is that this closeted, this defensive posture that judges take when their conduct is questioned is one that is sanctioned by the Judicial Council, and this is what has authorized a great degree of indiscipline across the behavior of judges in Nigeria.
And can one really exculpate lawyers who, in spite of earlier judgments, take briefs? You know, I mean, talk about the role that lawyers play in all of this, and the fact that these judgments are actually carried out by vacation judges. Should there be a limit to the kind of judgments that vacation judges can, you know, rule on?
Yeah, well, first of all, a vacation judge is just a judge who hasn't gone on vacation. So there is really no difference between one judge and the other. But in vacation, when judges take vacation, there must be someone to hear urgent matters. But a vacation judge has an onus placed on him to determine that the decision that he's taking is not only fair and just in the circumstance that he takes it, but that the urgency which forces him to take that decision is real. In many of these cases, it seems quite clear that there was no urgency which would not have allowed the other side to have been heard, and many of these decisions are given ex parte. That in itself is highly suspicious. But you asked an important question about the role of lawyers, and there is no doubt that senior lawyers in particular, and some junior lawyers don't really have the authority to approach courts and implicate them in fool's errands. But many senior lawyers are directly complicit at the behest of political actors and other bad hombres, I think is the word that has been used to refer to some of these people, to approach judges and to use undue influence, abuse of relationship, sometimes subversion by money and other entreaties. And these senior lawyers very often are those by whom access of bad actors is guaranteed to judges. Of course, the judges are responsible. The judges are responsible for their own conduct. They've sworn a judicial oath. But the fact is that there are no doubt lawyers who are involved in very bad practices with the judiciary, and very often the route to bad action by a judge is through a senior lawyer.
I don't know. Let me put this together. Talk to us briefly about ex parte motions. You know, what that really implies in the scheme of all the things we're experiencing. The CJN says they'll appear before him and then onwards to the NJC. What are your expectations? And maybe you should add, for good measure, the place of politicians in all this.
Well, politicians in Nigeria, politicians are obsessed with the pursuit of power. And very often they fail to see the big picture in the damage that they cause to systems which are meant to sustain our government, our democracy. So I don't expect politicians to reflect the highest professional conduct and the professional behavior, or even moral behavior, when they seek in their desperation to acquire power. But judges and lawyers are specifically trained to carry out their actions by a settled system of ethics, a certain code of moral behavior, and by a settled system of law. And if you've had this training and you take an oath to uphold the law and the Constitution, then this should cause you to have sleepless nights if you're going to be approached and by some person who doesn't have your responsibility and being cajoled into breaking the law. You ask, what is my expectation? Well, I think that unless the system of accountability is enforced with rigor, unless there is a certain consequence that will follow and that it will follow quickly, I think that by and large, corruption aside, the biggest impediment to the authority and the credibility of our judiciary is delay in the delivery of decisions. This is why people have to approach vacation judges and go ex parte. And if there was efficiency about the system, then many of these errors, if you call them that, could be corrected very swiftly. Now, this process by which you go to the Judicial Council when you complain against a judge is cumbersome, it's long-winded, and very often the tribunal, the council is going to err on the side of judges because I said it's cloistered, it's closeted, and they feel that protecting the dignity of judges is their most important function. Of course, it is not. And final point I think you made is about ex parte orders. Ex parte orders are in extreme cases a legitimate tool of the law. If you need to get an order and you go before a judge and explain that there's an urgency which makes it inevitable that damage that is irreparable will occur to you in the short time within which you need to inform the other side, it's possible to give an order. But it's an order that is given in exceptional circumstances upon the clearest of evidence, not with frivolity, and one that gives the other side the earliest opportunity to be heard, to rebut a case that has been made on one side. And then again, it's a matter of discipline, because if a lawyer goes before a court on an ex parte order and misrepresents the facts on the law, then he ought to be disbarred and never be allowed to practice law again.
All right, thank you so much, YEMI Candide-Johnson, Senior Advocate of Nigeria. Let's hope that this legitimate use of the law is not unduly abused in Nigeria. Thank you so much for joining us.